Good morning, viewer. Welcome to our Fusak TV. Here's the breaking news. Yes, opinion. How liberals should rethink their view of the Supreme Court. The last time liberals controlled a majority of the US Supreme Court was 53 years ago, June 23rd, 1969. That's when Chief Justice all were retired upon the confirmation and swearing in of his successor, Warren Burger. Since then, liberals have engaged in a constitutional strategy of getting to five justices, throttling their argument to the court's swing justice. Whether it was Potter Stewart, Louis Powell Jr., Sandra Day O'Connor, or Anthony Kennedy, liberals had no constitutional theory other than finding a fifth vote to protect the rights of minorities and women. Conservatives, on the other hand, have spent several decades developing a constitutional theory. Originalism, interpreting the constitution based on the original intent of the drafters or on the original public meaning at the time of the provisions enactment, designed to roll back the New Deal administrative state and to overturn the Warren Court's precedents protecting minority on privacy rights. As the leaked draft opinion in Dobbs v. Jackson overturning Roe v. Wade should make abundantly clear, the liberal search for a swing vote on a 6-3 conservative courts is a false errand. The democratic political process, suspending the filibuster and passing a federal law preventing the states from abridging abortion rights is their only hope. In that vein, perhaps liberals should reconsider a constitutional theory that many of them championed for the first half of the 20th century yet abandoned during the 1960s. Judicial restraint. Judges who practiced judicial restraint often upheld state and federal laws and rarely overturned the court's precedents. This approach appealed to liberals who believed that the court should defer to democratically elected bodies while ensuring that minorities were not discriminated against or shut of the political process. Defense of democracy was inspired by Chief Justice John Marshall 1819 opinion in Mac College versus Motherland upholding the constitutionality of the National Bank. In Mac College, Marshall described the Constitution as a great outline that was intended to endure for ages to come and to be adapted to the various crises of human affairs. Marshall contrasted the Constitution's generalities with the prolixity of a legal code. He recognized that the Constitution granted the federal government broad powers and that the document empowered the people and their representatives, not the states, to make national policy. One of the first scholars to highlight the significance of Marshall's deference to democracy was Harvard Law Professor James Bradley Thayer in an 1893 Harvard Law Review essay, The Origin and Scope of the American Doctrine of Constitutional Law. Thayer said that the court should not invalidate a federal law unless it was unconstitutional beyond a reasonable doubt. Any doubts, Thayer argued, should be resolved in favor of constitutionality to encourage elected officials, not 9 unelected justices, to govern. The progressive push for deference to democracy gained steam during the early 20th century. From 1910, 1912, former President Theodore Roosevelt attacked the court for invalidating state and federal minimum wage laws, child labor laws, and laws protecting the right to belong to a union. At the court, Justice Oliver Wendell Holmes Jr. and Louis Brandeis dissented from many of those decisions and endorsed Marshall and Thayer's ideas about a flexible democratic constitution. Holmes believed that the country would be okay if the court lacked the power to invalidate a federal law. Brandeis viewed the states of laboratories of democracy and warned that the court should strive to avoid constitutional questions. A young Harvard law professor, Felix Frankfurter, praised Roosevelt's speeches and Holmes and Brandeis' dissents as articulating the proper role for the court in a democracy. In 1916 and 1917, Frankfurter successfully defended Oregon's minimum wages and minimum hour laws before the Supreme Court. In 1923, he attempted to defend Washington, D.C.'s minimum wage law for women based on McCulloch's broad conception of federal power. The court, however, invalidated the minimum wages law in Atkins versus Children's Hospital as violating the liberty of contract in the Due Process Clause. Frankfurter believed that the Due Process Clause gave a conservative court too much leeway to impose its values on the country. A decade later, the country struck down many of President Franklin Roosevelt's New Deal programs as exceeding the power of the federal government. After Roosevelt won a second term and proposed expanding the number of Supreme Court justices in 1937, the court overruled Atkins and upheld the constitutionality of minimum wages law as well as Roosevelt's New Deal programs, including Social Security. As a Roosevelt appointed Supreme Court Justice, Frankfurter established himself as a leading exponent of judicial restraint. He was willing to overturn precedent to outlaw racial discrimination and to protect the rights of criminal defendants. Yet, unlike many of his liberal Warren Court colleagues, he preferred to defer to the elected branches. Might, in the form to 5 votes to overturn a precedent did not always make right. He embraced Marshall's idea of the Constitution as a framework of government. Thayer's reasonable doubt standard of judicial review and Holmes and Brandeis' deference to legislatures and willingness to avoid constitutional question. Frankfurter opposed government by judiciary and put his faith in democracy despite its imperfections such as the Electoral College and the malapportioned U.S. Senate. A plea for judicial restraint in the name of democracy probably won't change the outcome in Dover or prevent Roe from being overturned, but it may be important for those who don't want the court to act like a third legislative chamber. Liberals have criticized the court for its hostility to Congress and the administrative state, but they need a constitutional theory to counter organism rather than simply saying we are right, you are wrong. A more robust theory of judicial restraint could curb the court's excesses and reinforce the country's commitment to democracy. Beyond the report for